All right, today we turn to Aquinas' discussion of the act of justice. We've talked about what justice is and how it's preceded by the idea of right, that there is right, a natural duty, a natural due in certain relations, and others which are achieved by agreements. One we call natural right, the other we call positive right. And justice is the will to give people their rights, to give others their due, give them their rights. And now we're going to talk about what the act of justice is. We don't just call the act of justice a just act. We could, but Aquinas gives it a name. And it's a little confusing name because the name that he gives it, the sense of what a just act is, has come down through the centuries and continued to interact with other definitions of justice. And so, for example, when you were doing contract law, you would have come across this same word, restitution. And in one way, it means the same thing that Aquinas is talking about, but in the history of contract law, we could never kind of get away from this notion that Aquinas has of restitution, which is not something particularly pertaining to contract law, but it's what every just act is. Every just act is restitutionary for Aquinas because by restitution, he just means an action that either conserves in two people relating together, equality, balance in the exchange or transaction, the way that I interrelate with somebody. If I do something to them and they do something to me and it's balanced, then restitution has been given. If they've acted on me and I give back to them an appropriate amount, for example, you work for me and then I give you a wage, restitution has been done. If a judge finds out that you have worked for me and I have not paid you and he orders you to pay me, we might call that enforcement of contract. Aquinas would call that restitution. But there are many cases in contract law where the contract may fail and our sense of justice is so overwhelming that nevertheless there should be some compensation given, that people have pulled back this word restitution and recognized a remedy in restitution where the action for contract may fail. So, for example, if I say, let's have we orally agree that I will buy land from you for $1,000,000, and it's an oral contract, so it's invalid under the statute of frauds. And I pay you as a down payment, I pay you 500,000 won. Okay? And then you say, oh, I'm not going to do it, and I sue you in contract, and the court says statute of frauds can't enforce the contract. And then I say, well, surely I should get my down payment back then. And then that would sound in restitution. Where does this come from? It comes from the fact that when contract law was being developed, people said, but wait a second, justice is not exhausted by contract. There's this background notion of restitution which comes in. It's natural, it's fundamental. We don't exhaust justice with contract law, and so we have to recognize restitution. And the history of law, if Aquinas is right, the entire history of law, of commutative justice, when two individuals sue each other, is all about restitution. And your concept of justice is different. And so you should take Aquinas' arguments here not only as very good examples of how you perform natural law arguments, which is by appealing to fundamental concepts and making basic deductions from them, but in a historical sense, you might think, wow, my notion of justice does not focus on the act of restitution. Maybe Aquinas is wrong. Maybe you're wrong. This is a great challenge. We may be justified in talking the way we do, but maybe we would be better off thinking the way Aquinas does about the act of justice. So in the opening slides, I want to impress upon you the difference and the importance of this question. Is the act of restitution fundamentally what the act of justice is? Is that a good way of organizing your idea of justice? Because it's not the way that we do it. First slide, please. So generally speaking, modern justice, what we mean by justice in the modern sense, I'm just speaking popularly, theoretically, is following certain rules addressed to the state. A just state is, the UN would tell you, it's a state that has certain rules in place to protect human rights or what have you. Justice typically is a vision of an outcome for a society. A just society is a society that looks a certain way. It's an outcome. Justice is an outcome in a state. You may have ideas like this. It's a society where there's economic equality, or there's racial equality, or there's equality between the sexes, or whatever your particular notion is, or there's religious freedom, or whatever. All of which are, great ideas, okay? But this is our notion of justice. Usually it's a statement about a quality of society addressed to certain kinds of standards where you could look at the society and make a determination about whether that's true. Very challengingly, there is very little formal distinction in this idea between commutative justice and distributive justice. In fact, it's predominantly a distributive idea. What does the state give to people? What does the state give to individuals? That more or less exhausts our notion of justice today. And that is very scary because this is a modern idea that comes with totalitarian Marxist societies. It's the idea that justice fundamentally is exclusively distributive is a very scary idea. Because, remember, what we mean by commutative justice is we think that Aquinas thinks, there's a distinctive justice. There are distinctive issues of justice between individuals that must be recognized and preserved. So if you focus just on distribution, if I'm deciding whether to enforce a contract between two people, I don't look at the justice of their interrelation. You agreed to work for me for so much money. You might look at, well, if we enforce this contract, then there will be economic inequality, so I'm not going to enforce it, the judge says. But you say, wait a second. I paid him money to do this work. He didn't do it. That's unfair to me. And the judge goes, yeah, between you two it's unfair, but I don't care about that because I only care about the ultimate outcome of society. And in my torts class, I've sometimes noted to you in tort cases where judges impose liability on parties, not because they are applying the normal standards of fault that we find in modern tort law, but they say, we want to do this because it will improve the distribution of goods in society. And this is very typical with modern instrumentalist, let's use the law to achieve certain outcomes. All of this way that we look at justice is wholly alien to Aquinas, because Aquinas says the core idea of justice is about you. The core idea of justice is about you, whether you are a ruler or whether you are a citizen. It's a distinctive kind of human excellence. Just like I look at a brave man and I go, wow, look at how he ran into a burning house to save those kids. What a brave man. He risked his life for others. I would be afraid to do it, but he was brave. So too, I look at a person who is making a deal and keeps his promise even though it's difficult for him, and I say, wow, what a just man. Justice it's a virtue of people that we praise. It's a virtue that we want for ourselves, to be always willing to give other people their due. In any kind of exchange, an exchange here could be a contractual exchange, an exchange of goods, but it means any interaction. It would include a case where I robbed from you. That's a kind of interaction, not a good one. But any kind of interaction is subject to this analysis. What do we want? if we are doing justice, Aquinas says, look, right just means maintaining a certain kind of proportion equality between two people. So that what happens in the exchange is not that an imbalance between the positions of the parties happens, but a balance is maintained. Why? Because we're talking about two individuals who are equal under a sovereign. And so their equality should be maintained. Okay? Justice is the same for the state and the individual, because the state, unlike in modern thought, is not this magic ultimate thing for modern people who don't believe in God. They just believe in facts of power. The state is the ultimate. There's nothing more powerful than it. It's the ultimate reality. Hegel called the state God moving through history. Not his best moment. It's a dumb thing to say, but that's the sense, particularly as Hegelianism is interpreted in Marxism. The state is the ultimate and most fundamental reality. It's an entirely different thing. Just as we've been reading in Job, you can't simply apply human ways of thought to God. You can't apply human standards of justice to the state. The state just works out its will in society. Not so for Aquinas. Justice for the ruler, justice for us, the same thing. If you are deciding a case between two people, judgment is just the declaration of the right. You should declare what would have been a balance between these two parties. A just man as a citizen and a just man as the ruler display the exact same virtue, that of seeking to give everyone their due. And in exchanges between individuals, I'm either keeping my contracts, respecting other people's rights, or, in the case of a judge, I am restoring the imbalance. That's what makes me just. So think about that. Think about the great difference between the way we think about justice today, typically, maybe you're different, and the way that justice is described to us in the various ideas and ideologies that we hear. Next slide. So it's very radical to say restitution, making restitution. Restitution really isn't that hard of an idea. Restitution is, can I take your water bottle? Yes. You consent to take your water bottle? May I borrow your water bottle? Yes? Okay. I've just borrowed her water bottle. Restitution is very simple. It's her water bottle. I give it back. That's it. Key paradigm case of restitution. If I have something that belongs to someone else, I restore it. If I have something that belongs to someone else, there's some kind of imbalance. It is due to her, right? She has possession of this now. I take it either voluntarily, she offered me a loan, or I take it involuntarily. She says no, and I take it. In either case, there is a restoration of balance because I have something of hers, and then I give it back. And of course, that's not the only way that I could create an imbalance, by taking a thing. There are other things that I can take other than property. For example, if I took your health by shooting you, I would also take something that is due to you. If I took your peace by assaulting you, that was also something I can take from you. If I take your freedom by locking you up, I take something else that belongs to you. If I enter into your property and disturb your sole possession of the property, that's something else I take from you. Okay? Does that make sense? So, restitution, very simple idea. Aquinas says every act of justice is simply an act of restitution. It is maintaining or restoring that balance that equals should have. Okay? He does not identify justice, very importantly, as we tend to do today, with a specific list of actions or rights. Justice is preserving the inalienable right to life, liberty, and property, or something like that. There's a list of rights, and justice is simply observing it. Justice is observing those rights. No. Justice is a relationship of equality between me and you. That's what justice is, Aquinas says. It's in principle never reducible to a specific set of rights or actions, because it is a relation of equality with you. It has an infinite number of circumstances and ways that it could manifest itself. It's just like your relationship with your parents or your husband or your wife can never be exhausted by a specific list of things that you should do. If I get sick, my wife should do one thing. If I'm healthy, she should do another. If I'm rich, she should do one thing. If I'm poor, she should do another thing. All the circumstances of life, the infinite number of circumstances, are summed up very simply in the way that we preserve balance in our particular relationship. And that's what Aquinas says is involved in justice. The goal, then, is not a particular pattern of social life. We don't think of an ideal kind of social life. The ideal is that we maintain a particular type of relationship. The goal of justice is to maintain the proper relationship of equals. I'm talking about commutative justice here, not a particular set of rules or rights to be embodied. And this is really, as we'll discuss in just a second, what Aquinas does in question 62 is really just another way of restating the golden rule that Jesus Christ taught us. Justice subsists for Aquinas in mutual recognition and regard. Whenever I approach you for any kind of interaction, exchange, interdealing, I want to view you as the same as myself. I want to give you what you are due, just as I desire what is my due. If I think something is my due, that's what I want, and I want you to have the same thing. I am just because I'm not looking at myself and thinking about my due. In all my interactions, I'm constantly willing other people to have what I want. Next slide. Jesus taught us a very challenging thing in the Sermon on the Mount. He said, you want people, therefore, however, in whatever way you want people to treat you, in that way, treat them. Do unto others as you would have them do unto you. This is the law and the prophets. Now, what's challenging about this is the equation. The equation of this with the law and the prophets. I've read the law and the prophets. I would not think to summarize them by saying all the law and the prophets can be summarized as you would have someone do to you, do to them. Jesus says that's what it is. That's all it is. Okay? And your response to that should not be, I heard that in Sunday school. Your response to that should be the same as when you hear Aquinas say, justice is always restitution. You should go, wait a second. Restitution is when I give back something that belongs to someone else. That doesn't sound like all of justice. I've gone to law school. Justice is much more complicated than that in courts. We argue about all kinds of things. And Aquinas says, no, it's just restitution. Every act of justice is an act of restitution. That's all it is. It is about regarding other people as your equal and seeking out to maintain that equality. If you've disrupted it, then you restore it. If you're entering into an agreement, you maintain it. That's it. And this is just saying the same thing that Jesus is saying. It's equally radical, it's equally powerful, and it's equally different from the way we usually think today. We don't speak this way because we don't place the maintenance of human relation, the love of other people, the regard of other people, at the center of our idea of justice. We have various clever ideas about how we can avoid the difficulties of life without having to love each other. The last thing I want is a politician or a government telling me that we're going to have a just society because we're all going to love each other. But politicians, what I want them to tell me is, we can have justice and prosperity, and I never have to think about you or love you. I do not have to give you what I want for myself. I do not have to treat you and seek your equality. There's going to be a clever way that I can avoid all of that and just think about myself. And Jesus and Aquinas, and I think Aquinas is making a great point here, say, nope, this is all of it. All of it is found in this way. Okay? There's another summary of the law Jesus gives. God, he is God, so that's okay to say. I didn't mean to say God, but I said it, and it's correct. God says to us, all the law and the prophets are summed up by loving God and loving your neighbor. This is just giving you a little further challenge and advance. What does it mean to love my neighbor? Does it mean to kind of feel soft-hearted? I really love teddy bears. They're so cuddly. I sleep with one every night. As soon as I put my head on his furry chest, I go right to sleep, knowing Teddy is there with me. Okay, how many of you sleep with teddy bears? Come on. I know you. You told me. He didn't tell me that. I'm just kidding. That kind of fuzzy, sentimental feeling of love, Care Bear love, is not love, as Jesus means it. When I love somebody really, then I do to them what I would want done for me. I love others as I love myself. There's no problem with loving yourself. You love yourself enough. You don't have to worry about that. The big problem is loving others. Okay, next slide, please. So Aquinas would say when we go to a judge and we ask for justice, therefore we're asking for the judge to order restitution, that individual to give me restitution always. That the fundamental thing we're doing is we're always pleading some kind of equality that has been disrupted by the other person's action. I gave him 100,000 won and he gave me nothing. He took my water bottle and gave me nothing. So he should return my water bottle. Okay? Very, very easy. The ground of this is not one person's right. This is very important. When Aquinas says the word right, he does not mean something in one person. He means a shape of a relationship that is held in balance. Rights do not subsist in people, they subsist between people who are in the right relationship. And you should know that the idea of restitution, which has haunted law for 2,000 years now, which has always pressed in at the corners of law like it does in contract law, where we're trying to deal with people's voluntary relationships, and then sometimes we just say, well, contract doesn't quite fit here, we need to turn to restitution. It always presses in. It arises from a very spiritual kind of question. Christians asked very early on, Augustine, while the Roman Empire was still a going concern, spent a lot of time discussing this question, for example. If I've done something wrong to my neighbor, I know I've done something wrong, I stole from them. So oh my goodness, is that a squirrel? I do something wrong. I thought I saw a squirrel. Did you all see that squirrel? I thought it was a squirrel. Never mind. I guess I'm wrong. I do something wrong to my neighbor, and then afterwards, I'm drinking, enjoying the water bottle, and then I start to feel conscience. I say, I shouldn't have stolen the water bottle. Stolen water is sweet, but I've wronged my neighbor. And then I think, I repent. And then I still have the water bottle, at home with me. And then I think, did I really repent? I mean, I'm sorry I did it, but I'm keeping the water bottle, okay? I'm keeping the water bottle. It's a great water bottle. It's green. It's well-formed. It's filled with water. Is it water? Not apple juice or coffee? Just water. Good. Best for hydration, water. I keep the water bottle. Okay? Have I really repented? This is the question. Have I really done what I need to do to deal with my sin before God? If I feel sorry, honestly, I feel sorry that I stole the water bottle, but I don't give the water bottle back. I don't perform restitution. And Augustine and other Christians early on said, when you do wrong, Jesus Christ forgives your sins, but a true attitude of repentance is inconsistent with you continuing the wrong of not doing restitution. To complete what you're doing in repenting for your sin, you need to do restitution. I go and I say, I'm very sorry I stole the water bottle. How about a big round of applause for me and my act of restitution? Thank you very much. She just got what was due, but I've performed a great action. I know that I'm forgiven by Jesus Christ, but then I want to do a commensurate justice. Jesus was great in his righteousness to me, and so in response to Jesus' grace to me, I want to be just to others, right? Jesus has loved me. I want to show love to others. So when I've committed a wrong against my neighbor and I feel bad for it, do I get to keep the water bottle after I feel bad? And Christians have continually said, no. It is basic to what you do when you do wrong, that you do restitution for the wrong that you have done. Next slide. And this then generated a whole host of questions. First, do I have to give back what I've stolen? What if I didn't steal it? What if I borrowed it? Do I have to give that back? What about damages that I've caused? Do I have to pay someone damages if I've injured them? Not taken a thing, but injured them? Zacchaeus, when he repented of the wrongs that he had done, gave back more than he had stolen from people. Do I have to give back more? Should I give her back the water bottle and a second water bottle? What does restitution require in terms of amounts? What if I had taken the water bottle, but instead of saying squirrel, I had struck her to take the water bottle? Do I just give the water bottle back to make restitution, or do I owe her something beyond the water bottle because of the way that I took the water bottle? Is restitution about things alone, or is it about things and actions? So that you must give restitution, that's Article 1 that we'll be reading today. That sometimes you have to give more, that's Article 3. What if I don't take anything from you or cause you any loss, but I prevent you from getting something advantageous? I know you're on the way to the store to buy something that you need, and I let the air out of your tires to keep you from going and getting what you need. Do I have to pay restitution for what you couldn't buy? You're on your way to make a business deal. I prevent you from making the business deal, and so you lose a profit. I didn't take anything from you. Do I still have to make restitution for what you lost? What if can I take your water bottle again? Yeah. What if I take the water bottle, I steal it, okay? And I think, I need to make restitution of this, but on the way to give restitution, I lose the water bottle. And by the time I get back to give it back, I no longer have the water bottle. Maybe it was stolen from me, or maybe I lose track of it. What should I do? I can't give the thing back. Should I give up on my plan for restitution, or should I buy a new water bottle, a better water bottle, and make restitution that way, or pay damages? And that is Article 6. What if I didn't take it at all, but I commanded someone to take it? Dean Lee, go steal the water bottle. Or Dean Lee didn't know how to steal the water bottle, and he says, how can I steal that water bottle? And I go, she's a sucker for the squirrel thing. Just shout squirrel, and she'll turn around and you can swipe the water bottle. Or what if he said, I'm so thirsty, I don't have any water. And I said, my advice to you is steal her water bottle. If he then steals the water bottle, do I have to make restitution? I didn't take it, but I commanded, I counseled, I encouraged. Or what if I know Dean Lee took the water bottle and I don't tell anybody about it? I hide the fact that he took the water. Should I make restitution in these cases? How long can I delay? That's Article 7. How long can I delay making restitution? And this is, of course, a major issue in the Bible. Particularly, you may not think of delaying as something that requires restitution, but the Bible says it is, particularly in the case of workers. If I delay their wages. So when I get done giving this lecture today, the university isn't going to pay me. They're going to make me wait until payday. This is the injustice that I labor under every day. I'm kidding. Now, this is these kinds of issues. Withholding of what is due is itself something that requires restitution. All right. So let's skip forward 2 slides. That was a great slide, but we're not going to do it. Okay, very quick review of where we are. So we are talking about virtue. We're talking about virtue. We're talking about what we like, what is good to see in man. And justice shows up because we distinguish inward virtues like courage, like self-control, like prudence, that are predominantly wrestling with things in yourself, your desires, your fears, your attitudes towards action where you don't think about them in a responsible way. Prudence, temperance, or self-control, courage. Those are all things which are inward looking. Justice is the virtue of how I deal with others. It's a distinct virtue because it deals outwardly with others. Okay? So when we're talking, next slide. So when we're talking about that particular human virtue, justice, we can make important distinctions within that virtue of justice. Some actions, which we would call the general virtue of justice. A lot of times when the Bible is speaking about justice, as in do justice, that's what God requires of you. It's speaking about this first sense of a general virtue that in all things that we do, we should be acting for the common good. We should be acting for the good of all. All of my actions can be summed up in that regard. But there is also another virtue, and that we can distinguish these two. We call it a particular virtue. It's not the whole virtue. It's the virtue of acting rightly towards individuals in actions. And we call that a particular justice. And it's more limited. It's much more limited, okay? So with respect to this particular justice, we can distinguish 2 types. And this is whether you make this distinction is critical. And one way of understanding what's different about judging in the United States today than in the 18th century or the 19th century is we merge these 2 ideas of justice. Particular justice is about how the individual acts with respect to individuals. But there are 2 ways, Aquinas says, to act with respect to individuals. The whole in respect to an individual, this is distributive justice. The idea here is we're going to hand out some common property. The state has money, and we're going to hand out benefits to people. How do we distribute it? One way to do it would be to give everybody an equal share. Another way to do it would be to give poor people more and rich people none. Okay? We're going to hand out awards in the Army. We could give everybody a medal. Everybody who's in the Army, we could give a medal, or we could give a medal to the people who were injured fighting. Maybe we don't have enough medals. We're trying to decide, who should we give medals to? Should we give medals to the people who are injured fighting, or to the people who repaired the most tanks? We have to make a choice. That pertains to distributive justice, taking what is common and giving it to individuals. And that's very different than commutative justice. Commutative justice is the justice that pertains to relations between two individuals, not the common to the individual, but individual to individual. And in that regard, if a judge were to say, hey, I'm going to decide this case by always deciding for the poor guy, no matter what the case is, I'm just going to look at it and I'm going to give benefits to the poor, that would not be doing commutative justice, because you would be doing distributive justice. And the goal of a court of justice, in the commutative sense, when two people sue each other, the state is not a party. The justice, if justice is going to be done, is going to have to be done between those two individuals according to the distinctive norms of individual justice. Next slide. So now, thinking about particular commutative justice, justice between two people, Aquinas, last week's reading, says, look, you can map out the whole broad scope of most of what we think of as the causes of action just by thinking about various divisions between different types of people, different types of things, different ways that people can act. And he focused most importantly on the difference between voluntary and involuntary commutations, involuntary and involuntary reactions. So involuntary, I hit you. You don't want me to hit you, I hit you. For purposes of commutative justice, that's going to make a huge difference. Then there are voluntary contracts, deposits, bailments, loans. A very basic idea in the way that we organize commutative justice is going to be distinguishing between voluntary or involuntary. And then today, when he deals with restitution, he explains more about why that's true. If you get nothing out of the understanding of restitution, make sure you understand this very basic point. Next slide, please. Because the act of justice is restoring the balance in a voluntary, a just transaction, where I agree to let you have something, the focus of restoration is just on the thing. There's nothing wrong with the action. I willed you to do the action. What you did to me, taking my water bottle, was voluntary. I gave it to you. And so the duty of restitution is summed up in returning the thing. I loaned it to you. All you have to do restitution is give it back to me after you're done with it. And you're done. Because the only thing at issue is the thing itself. But with involuntary exchanges, where I steal the water bottle, now there are two things at issue. Two things that have to be dealt with. One is the thing. I took your water bottle. But there's another thing. My action was wrongful to you. And so there's more at issue in giving restitution for a theft than merely returning the thing, Aquinas says. Restitution has to be given for what I did, invading your right of possession, invading your right of ownership, invading your peaceful use of your goods. So Aquinas gives us a fundamental reason why voluntary and involuntary are fundamental categories in commutative justice, because in one situation, we're just thinking about the things. All we have to do is figure out how to make an equality of things. But with the involuntary actions, we both have to restore the thing and deal with the wrongs that arise from the involuntary action. Okay? Good. Well, let's get into some of his arguments now. Next slide. So the first article, he just sets up that all justice, commutative justice, is about restitution. Restitution is restoring or maintaining a kind of equality. It can happen that there's inequalities through voluntary or involuntary actions. And the basic restoration of equality is giving something back. But he says the more we think about it, we don't just take things, we can take other kinds of interests, not just physical objects. I can take your health. I can break your arm. I can take away your reputation. I can do all the kinds of things that we talk about. So we've talked about that a lot. Let's go on to the next one. All right, so basic question. If I take something wrongfully from someone and I want to make restitution, do I just give them back what I took? Or do I have to give them back more? Is restitution that balance? It seems like the balance would be restored if I give back exactly what I took and no more. And Aquinas says, yeah, there's a lot of sense in that. If I take a water bottle, I give back the water bottle, I do restitution. But he says, and this is what we were just talking about with voluntary versus involuntary, the balance has to be considered with respect to two things. If the only thing at issue, as it is, for example, in a voluntary transaction, is the thing, then giving the thing back is enough. If you loan me your car for free, I say, hey, I need a ride, and you say, well, take my car. I don't need it today, take it. I say, really? You go, yeah. It needs to be driven anyway, the battery's getting low, drive my car, you'll do me a favor, it'd be great. So you loan me the car, and then I'm thinking, now what do I do in this situation? It's very obvious. What do I do when I borrowed somebody's car? It would be wrong not to return it. The car belongs to that person. I should return it. What else do I have to do? What else do I have to do? Nothing. Restitution, justice is complete when I give the car back. But now think about the situation where I see your car and I need the car and I just steal it. I just steal your car. I take it. Now, in addition to the taking of the car, where restitution needs to be made, I have involuntarily done something to you. Before you freely gave it to me, but now I have not only taken your thing, I have taken the control that you had over the thing. I have taken two things from you, the car and your relation to the car. I have taken it. I have broken that bond away. In the case of assault, even if I don't touch you, there's a need for restitution. I've taken nothing from you. I didn't harm your body, but I violated you in a particular way that needs to be restored. So Aquinas says, oftentimes, and what he's, by the way, if you read the objections in this passage, he is thinking here about the provision of the scriptures that say, when you steal a sheep, you should give back 4 sheep. And when you steal an ox, you should give back 5 oxen. You should give back 5 oxen. And Aquinas says the reason for this is that restitution is complete with respect to the thing if you give it back. But it's not complete with respect to the action, the wrongful action in the case of theft. Now, if you borrow a sheep, I don't know why you would borrow a sheep. Why would you borrow a sheep? For a birthday party. Can I borrow your sheep for my daughter's birthday party? Sure. What do I have to do? I just give the sheep back. 1 sheep for 1 sheep. But if I steal it, I have to give back 4. And Aquinas says this is because the action has to be considered as well as the thing in certain relations. But he says, how you deal with the action is not a matter of natural right. And so if you were thinking in Junius's terms, Junius would say, when you steal something, you should do more in restitution, the Bible teaches us, but how much more should you do? Should you give back 4 sheep or 5 or 6 or 10? He would say that has to be determined by positive law. And so that doesn't bind us, he says, but the principle that it teaches us, which is in the case of theft, restitution requires more than a simple return of the object. That is taught by the law. Next slide. Aquinas' 4th argument. What about restitutions for things I have not taken? And what he means by things I have not taken is, what if I don't take something from you, but I prevent you from getting something. I know you're on the way to get a job. You're on your way to a job interview, and I don't want you to have a job because I don't you. I like you. This is a hypothetical, okay? I take a knife and I put it in your tires and I flatten your tires and you miss your job interview and you don't get the job and your life is ruined forever because I did this thing. And Aquinas says, look, even if you don't take something from someone, you don't injure their body, you can still have to make restitution. Why? Well, because there are two ways that you can take something from someone. You can take something, the actuality from someone, or you can take a potentiality from someone. You can prevent something from acquiring something that they likely would have had without your wrongful, involuntary interference. If you might remember in tort class, this is a very lively debate in tort law to this day. When we talk about lost chance, if a doctor's negligence, you had a serious disease and you were more likely to die than not from the disease, and he misses the diagnosis, so you don't get treatment, and then you certainly die, should you be able to recover for the lost chance that you had? This is exactly what Aquinas is talking about. It gives you some sense of the power of Aquinas' thinking, that just working through these ideas in a logical way, he's touched on many modern debates and arguments that we have today. So he says you should pay compensation, but just as in the lost chance doctrines of the state, he says you probably should pay less compensation than for taking an actuality, because there's only some probability that they would have gotten the thing. It's not worth the same thing as an actuality. So if a farmer plants his field with seeds and you go through and you dig up all the seeds and take them out, he didn't have a harvest yet. He had the probability of a harvest, so you should pay less than if you had taken the fruits themselves. That's exactly what modern law says. Very interesting. Next slide. I love this series of questions. Should you give restitution if you lose something? I steal the water bottle, but then I lose it, or somebody steals it from me. I sell it. Should I give restitution? If you focus on the thing, I no longer have the thing to restore, and so I can't give it back. And again, he says, well, there's two different things that we have in restitution: the thing and the action. And if we think about that, there are three kinds of acts that can cause loss. And these are just symbolized by theft, loan, and deposit. So he says, look, in the case of theft, whether I lose the object that I've stolen, the act provides a full justification for me to restore the amount that I stole plus something. We've already talked about that, right? It's not my benefit that gives me the obligation of restoration. It's your loss. Equality can only be restored to us if I make up for your loss that I caused involuntarily. That's the only way equality can be restored. If restitution depended upon my benefit, well, then I'd have a good argument. If I steal something and then I lose it, I have no more benefit than you. We're both losers. I haven't benefited from trying to steal from you. I had the water bottle for a second, but I lost it. Somebody stole it from me. But he says restitution doesn't depend upon the object. It depends on the loss that you caused. By the way, this is a huge debate in the modern law of restitution. Some people think restitution should focus exclusively on unjust enrichment, that the reason for restitution is unjust enrichment. Aquinas predicted this debate long ago, and he weighed in on one side of it. And he said, it is not unjust enrichment that justifies giving something back. It's not because the thief has too much, it's because the other person has too little. And he says the case of the thief shows you Because we wouldn't say to a thief, you don't have to give her the water bottle back because you lost it. You don't owe her any damages because you didn't benefit. It's her loss that's the issue, not your benefit. The third restatement of contracts specifically renounced Aquinas' position on restitution and said restitution is solely on the basis of unjust enrichment, not on the basis of loss. And a lot of modern scholars said, you're crazy. That's nuts. That's wrong. There's a big debate right now. Again, my point to you is the power of Aquinas' thinking is shown in part by the fact that these same debates are going on today, and they're major aspects of the way in which the law has to be determined. He says, consider theft and compare it with a loan. In the case of a loan, you give me something. Now, what happens if I lose it? Well, if you loan me something for the sake of your generosity, I receive your generosity, he says. Once again, we not only focus on the thing, but the act. You gave to me not for your own advantage, but you gave to me out of generosity and love. And there would be no equality, there would be no reciprocity, no justice, unless when I lost what you loaned me, I paid you damages for what I've lost. Even if it was taken without my fault, I still owe you the thing. I must give you back what I borrowed. This is a very important principle of biblical law. It used to be a very, very important idea of law. In the case of a gratuitous loan, I had to make restitution for the sake of your generosity, for the sake of the relationship, not because I had engaged in any fault. And he says, compare a loan with a deposit. In the case of a deposit, you give me the water bottle because you can't take care of it. You say, I'm going to go to sports day, I don't want to hold my water bottle. Would you do me a favor and hold my water bottle while I'm going to sports day? And I say, I will only do it for you because I like you so much. Yes, I will take your water bottle. Now it's totally unlike a loan. In the case of the loan, you were giving it to me for my benefit. In the case of a deposit, I'm taking it for your benefit. Now Aquinas says, if it's stolen from you, you have no obligation. You have no obligation to make restitution because it was taken without your fault. But if I lose it through carelessness, then I have an obligation to make restitution. And this is exactly the modern law of deposits. This is exactly the modern law of deposits. In fact, it was one of the ways that negligence law first got its start, was distinguishing situations where depositors, people who received deposits, had to make compensation from situations where they didn't. Aquinas does this stuff in paragraphs this long, but he maps out basic doctrines that still shape the way that we think today. Okay, last one. Aquinas' fifth argument, question 62, article 6. Must the one who took restitution... this is a continuation. Let's skip this one, go on to one more. Article 7. Aquinas maps out an entire theory of what you might call accomplice liability, or in civil law we usually call this secondary liability. What if I don't take something from someone at all? I don't make their condition less. Must I still give restitution? He says, sure, that can happen, because I can cause someone to have a loss not only by doing it myself, but by commanding it, by counseling it, by consenting to it, by encouraging it, inducing it. Or I can hide the person who stole it. I can help them hide their property. I can participate in the theft itself. I ask Dean Lee to shout squirrel, and then I do it. I'm liable for taking it, and Dean Lee is liable for shouting squirrel. So those are all direct ways of participating, but they're not takings themselves. He says they still cause the loss, and they still require restitution. You can also do this Indirectly, he says. In the case of indirect commands, he says there's going to be a question about causation, because we're going to have to investigate whether it really caused the loss or not. But he says, what if I see Dean Lee is going to steal the water bottle, and I withhold a command. I don't tell him not to steal it. I could tell him not to steal it, but I don't. I could be liable in that case. I see you two struggling over the water bottle, and I decide not to intervene. I hide the theft. All these things are ways of doing it. In the next slide. In the next section, very interestingly, if you remember the doctrines of single satisfaction and the question of contribution, Aquinas says there would be a problem if everybody who did this made restitution, because then the person would not get back one bottle back, they would get back 5 water bottles. And so he says, of course, only a single restitution is due, and the person who makes restitution then has a claim himself for restitution against all the other people who contributed. And this is exactly the debate that played out in American law concerning the doctrines of satisfaction and contribution. Aquinas, in the 13th century, just working through the basic ideas of restitution and how it should work, anticipated and correctly decided the law the same way that we have it in the United States today. It's remarkable. Here's a guy living in Italy and France in the 13th century. He's just thinking through about what it means to have balance in commutative relations, and he anticipates all of these questions. Last one we'll treat on. Next slide. I found this paragraph very intriguing. And there was a case in the United States involving this that was decided the other way. But I think Aquinas' doctrine is very important. He says, one that does not prevent a crime when he ought to prevent it is obligated to make restitution. For instance, rulers who are obligated to safeguard justice in their lands are obligated to make restitution if, because of their failures, robbers increase in number, because they're not preventing takings. Now, in the United States, you may know, over the last 3 to 5 years, we've seen property crime, public violence, assaults, murders increase dramatically, 50, 60%, because a certain group of leftists in the United States has declared that it's bad to put people in prison. It's bad to enforce laws. And seriously, I mean, they let people out of jail immediately after they beat people up, rob people. Whole states like California have said, we will not arrest people for stealing anything under $300, $500. And so people just walk into stores with bags and empty the store of its goods, and the police have orders not to intervene, because distributive justice requires that we not put so many people in jail, so we just won't arrest people who are robbing. And not shockingly, the result of this has been a massive increase in robberies, killings, beatings, attacks. Okay? Aquinas, interestingly, says very forthrightly, and therefore the government that allows riots, the government that encourages riots, encourages robberies, adopts policies which immediately lead to loss, should make compensation. Interestingly, the United States Supreme Court has ruled on this and said the government has no duty to prevent crime. The government, this was a case involving a boy who had been put in a foster home that the government knew was dangerous. The government knew that the home was dangerous, and they nevertheless placed the boy in the home, and the boy was beaten to death in the home. And the government was wildly reckless and negligent. But the court said, you have no obligation to protect people. That's not, you have no duty to do it. You can't sue the government for stopping to prevent violence. You have no obligation. If you call the fire department and the firemen say, hey, we'll finish our card game before we come, you can't sue them for not preventing the fire. If you call 911, or what is it, 119 here, 119, and the police say, "Oh, you're being attacked. Sorry, we're on lunch, can't come." You have no cause of action against them because the government in the United States rejects an obligation to prevent crime. Very interesting question, what it would be like if you could sue a ruler for policies that increased crime. Aquinas thinks you should be able to do it. The United States Supreme Court says no. But once again, I would just point out to you, whether you think Aquinas is right or wrong, it's very interesting that the same kinds of legal issues that arise in modern law are predicted so thoroughly by this question. It adds, it seems to me, an interesting argument that this must be right because someone in the 13th century just thinking about the concept of restitution could so easily determine major and fundamental questions, issues that still arise today. I would just point out the other way of looking at it, though, is these issues never go away. What exactly restitution requires is something which is blind to us because of our sin, because ultimately restitution is not about a set of rules and determinations that can be figured out once and for all, but it arises from the question that if I love you and I want to maintain equality with you and serve you, then I need to know how to do that. And we all know that the barrier between us and loving other people is not knowledge, but it's my selfishness. And this is again to remind us, Aquinas is not teaching us here that the way to achieve good societies is by carefully working out the duty of restitution. What he's teaching us is that a focus on loving and serving each other, a focus on what Christ teaches us, is the only way we can hope to have justice. And this is a worrisome thought for lawyers, because there is no amount of arguing about these rules that will bring justice, but only creating a new heart and a new soul in people that's oriented towards the love of others. Let's pray together. Father in heaven, we thank you for this chance to reflect on justice. We hope, Lord, that we learn the lesson of restitution, which is that we must love and serve others as we would be loved by them. In Jesus' name we pray. Amen.